Neither Chairman Blake nor I have opening statements this morning. We'd just like to welcome everybody and kind of jump right into the hearing. We have a full day scheduled, and we appreciate everybody's attendance and indulgence as we work our way through this. Try to stick to the schedule as best we can. I would comment again that we're taking testimony under oath, and our first witness is Commissioner Jeff Haste from Dauphin County. Welcome.
Good morning.
And if you'd like to raise your right hand and be sworn, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Okay, I know you have some prepared remarks, however you'd like to proceed.
Okay. I want to thank you for this opportunity. As you mentioned, my name is Jeff Haste. I'm chairman of the Dauphin County Board of Commissioners, and I was appointed to the Dauphin County Board of Commissioners in December of 2002. In April of 2003, I was elected by the board to become chairman, and I've been chairman since then. I'm pleased to appear before you to assist in your examination of the Harrisburg Incinerator project, which has had serious adverse consequences for the city, the county, and the Commonwealth. Allow me to provide some background of the county's involvement in this project. In 2000, the county's Act 101 plan directed all municipal solid waste to various regional landfills. Prior to 2000, the county and the city had engaged in extensive litigation whereby the city attempted to have its incinerator included in the county plan. Although the county prevailed in its litigation, the city and the county did enter into a settlement agreement whereby the county agreed to consider directing a waste flow to the city's incinerator in order to assist the city in financing a necessary retrofit of the facility. From 2000 to 2003, the county took steps to amend its Act 101 plan to discontinue reliance on landfill disposal and to incorporate resource recovery into its plan. A major concern of the Board of Commissioners was the potential reopening of the Dauphin Meadows landfill in the northern portion of Dauphin County, unless alternative disposal methods were identified. And if anybody followed back then, there were a lot of environmental issues with the landfill, as well as trash, as well as transportation getting to and from that facility. The transportation network that led to there was not built for heavy trucks, and there were many incidences of school buses and trucks having near misses and issues with that. So there were a lot of issues with that landfill. By 2003, the incinerator was closed by environmental agencies, leaving a $104 million of existing debt guaranteed solely by the city. For several years, the city had been urging and requesting the county's assistance in financing the retrofit of the facility, suggesting that bankruptcy was an option if the retrofit could not be accomplished. The county responded by awarding a long-term disposal agreement of county municipal waste to the city incinerator, subject to successful completion of the retrofit. Ultimately, the county agreed to guarantee a portion of the debt in order to facilitate the financing for this project. By 2003, the city had been working with Barlow for a number of years to develop and plan the project. The county, in considering its guarantee, retained special counsel, consulting engineers, and PFM as financial advisors to review the project. Our consulting engineer conducted a review of Barlow's past projects, reviewed the self-liquidating debt certificate and the engineering report to City Council. PFM reviewed the financial structure of the retrofit bonds to be guaranteed by the county and approved the related swaps, which were also guaranteed by the county. The county's guarantee was secondary to the city's, and at the time the city represented to us that the county's risk would not exceed 1 year's worth of debt service because the city, if unable to meet debt service in a given year, would appropriate and pay the deficiency from its next year's budget. This, of course, as we know, never happened. The county knew that there were risk factors associated with this project, including Barlow's lack of experience with respect to projects of this size, the lack of a performance bond, and the necessity to size the project in order to to cover repayment of the city's existing debt. With respect to the lack of performance bond from Barlow, the county reviewed and relied on the alternative security arrangements approved by the authority, which included a guaranteed maximum price contract, deferred payment for certain equipment until delivery to the site, and a 20% retainage on Barlow's contract price and reserve amounts within the construction fund. While the county reviewed and accepted these risks, it certainly could not have anticipated the catastrophic failure of the project, which we believe resulted from gross mismanagement and failed oversight of the project. The project was to be completed in 2006. By the end of 2005, the authority and the city had expended the entire construction fund, including the contingency and reserve funds. At that point, the project was not near completion. The city and the authority then borrowed an additional $25 million from CTI, which the county was unaware of, and a year later, at the end of 2006, those funds were expended and the project was still uncompleted. The security measures which the authority had put in place were never properly administered or enforced. This collapse cannot be blamed simply on Barlow's failure. Where was the oversight? Who approved the overrun payments? Or certificates failed to be authorized? Who were certain authorizations of the payments failed to be followed? None of these questions have been answered and were not addressed in the forensic audit. The forensic audit reviewed the planning of the project, but there has been no examination of the actual execution of the project. The authority's records concerning payment and administration of the project should be readily available for review. No matter how well a project is planned, if it is executed poorly without adequate oversight, then disaster is likely to result. The county had no part in play in the execution of the project and is now paying the cost of its failure. We understand that you have received testimony concerning the authority's forensic audit. For the record, we have appended to my prepared testimony a copy of the county's response to those portions of the forensic audit which dealt with the county's guarantees. Before concluding, I will address briefly some of the issues which we understand your committee has some interest in. The county guarantee fee. In 2003, we were advised that the city would be imposing a guarantee fee in order to provide funds to balance the then city's 2003 budget. We understood that the county's guarantee provided substantially more enhancement to the financing than the city's guarantee. We believed in order to maintain balance between city taxpayers and the rest of the county taxpayers, the county should also receive a guarantee fee. The county's guarantee fee was applied to the payment of county expenses associated with the issuance of these guarantees, including fees of the special counsel and our financial advisor. The balance of the fee was paid into the county's general fund. The 2007 financing. At the end of 2006, the authority had terminated the city's management agreement and hired Covanto to replace Barlow. It was too little, too late. I'll have to say, though, Covanto has done a very good job. The city and the authority then pressed the county to assist in additional financing to complete the project. Initially, the city requested the county to guarantee $60 million of additional debt. The county was very reluctant to do so and applied limitations on the amount of financing that the county would guarantee. However, in the end, we concluded that the bonds guaranteed by the county, which were of a higher priority than most of the other debt of the facility, could be paid only if the project was completed and fully operational. Some questions on suggestion of legislation moving forward. Currently, DCED approves only the proceedings with respect to debt issuance, including revenue projects certified to be self-liquidating. There have been suggestions that DCED's review should be more substantial. Any such requirement will add substantial delay and cost to the financing of public projects. We question whether a more critical review by DCED would have averted the crisis in this case, which resulted, in our view, from mismanagement of the project. A suggestion is that DCED be authorized to perform a critical review and analysis of those self-liquidating projects which are supported by a municipal guarantee where the amount of the financing represents a certain percentage of the municipality's available borrowing capacity. In other words, if that issuance, even though it's self-liquidating, would cause that municipality to go over its debt limit, those would be the ones that would be critically looked at. That way it would reduce the number that DCED would have to look at, but it would still look at those that are critical that could place a municipality into the situation this one is in. That would limit the review to those critical projects which may place in jeopardy a municipality's financial health. At this time, I would be happy to answer any questions.
Thank you, Commissioner. Senator Fulmer.
Thank you very much, and Commissioner, thank you very much for your testimony. In 2003, the county retained the PFM group to assess how much the county should ask as a guarantee fee for issuing the bonds.
Correct.
Was it normal practice for the county to seek a fee for issuing a guarantee, and why did you insist on the fee for this transaction?
If you remember, at that time, the answer was I was a new commissioner in 2003. I didn't know if it was common for the county to do that or not. But in dealing with PFM, they claimed that it was not uncommon, particularly with the city. Apparently, the city had done a number of those. And in doing so, I think going back to 2003, the city was asking $2.8 million of a guarantee. PFM had suggested the county should ask for 1.9. And how they came up to that was that was about the amount of savings in the insurance by having the county's guarantee. And over the life of the bond in the repayments, the county's guarantee was worth somewhere around upwards of $30 million worth of value to the project. Now, we initially were not going to ask for a guarantee. I remember this discussion well, but when the city insisted on having one out there, it in our mind was not fair for that to go to the city taxpayers and there not be some benefit to the county taxpayers as well.
Okay. Your January 30th, 2012 response to the forensic audit notes this, and I quote, "There is no doubt that the project was horribly executed by the authority, the city, and its agents." My question is, when did you grasp this, and what actions did you take to address these failures? And the second part of that question is, did you push to fire, change, or otherwise sanction any of the professionals who were advising the county, the city, and or the authority?
If you look back over the county's history, there were, I don't remember the exact year, but sometime after '03, there was some uneasiness with some of the professional advisors that we had. If you look at back to that, we did make a change. And in 2007, when, actually, if you go back to that refinancing, it took a whole year for that 2007 refinancing to occur. They came to us, and I believe it was in December of '06. It wasn't until December of '07 it was initiated. And part of that, the reason it took a year to do is there was a lot of going back and forth between the county and the city. There was an uneasiness at that time. And I remember this, the quote I had made in one of our meetings was, I felt like the Coast Guard rescue person. That we had been jumped into the water. We were there trying to help a municipality, help one of the major municipalities in the county get there. And we either had to, at that point in time, decide that it was time to no longer try to help them and let them drown, or to try to continue to rescue them. And we had a number of discussions back and forth. It went back and forth. They first came and asked for, I think it was $11 million. And we looked at them and said, be realistic. We know that's not adequate. What is adequate? And we couldn't get true budgets. I remember the first budget we got from them was written on a piece of paper, and we made them verify things and come back. And there were a number of public meetings at the commissioner's office. And I remember having a discussion with the city, with the mayor and some of the representatives, and said, you know, we're uneasy. What assurances do we have that this isn't going to go forward? And they would look through and they brought documents that showed that if it was up and running, it was producing revenue, it would be enough, there would be enough revenue to support and pay for the debt on the retrofit. They also said to us, listen, We understand and we don't take lightly the city's guarantee. We are second guarantor on this project. If in fact you as a county have to make a payment, have to come to our aid, we understand under Commonwealth law, we have to have a balanced budget, and the next year we will address that in our budget and we'll continue to work forward. Unfortunately, that cooperation hasn't existed since then.
Well, then that leads me to my next question.
Sure.
Prior to issuing the county's 2003 guarantee, what due diligence then did the county undertake to ensure the county and other parties would be protected? I.e., did you assess Barlow's technology? Did you assess Barlow's financial projections? Did you identify and assess any other issues of concern, or did you rely on the assessments of others?
Well, as I mentioned in my testimony, we hired a consulting engineer that looked at that. We had legal counsel that took a look at that. PFM was to take a look at it. We relied heavily on those professionals.
Okay. You previously said that you were concerned with the 2003 joint venture, and you said you insisted more protections be built into the agreements. However, in August 1st, 2003, letter to Mr. Georgian to Mayor Reed reporting on the meeting, the county's officials, and subsequent meeting with you, he said, and I quote, "We cautioned Chairman Haste that the resolution would cause a stir. His response was simply, any of those who would object to this transaction are not supporters of the county or city and would not support either administration. In sum, he expressed little concern and confirmed the county's support of this financing as being in the best interest of the county and the city. What made you so comfortable with the 2003 bond on August 1st, 2003, and did none of the subsequent issues that were raised from either August until the bond was executed that December cause concern for you?"
I would never say they didn't cause concern for us at all. We, again, if you go back to 2003, this project had actually started prior to me becoming a member of the board. The previous board had decided to, and I think rightfully so, to discontinue the ongoing battle between the county and the city over waste flow. That battle from the county and the city went back as early as the early 90s. And the county situation at that time, there was a landfill in northern Dauphin County that was very bad. It was closed, and they had the ability to expand at that point in time. The county was sitting with a situation. We had one part of the county asking us to keep the facility closed. We had another municipality begging us to help them move forward, that they had a plan to put together that would help them out. And at that point in time, the numbers appeared. And if you go back and look at it, the numbers that were put together by, I believe it was PFM and the financial, the revenues are on target. What fell apart from 2003 into 2006 and 7 was the expenditure of those funds. And those were things we did not see at that time, when hardly even saw in 2006 when we were trying to do that. But if you go back to it, the revenue projections were pretty close to where they were supposed to be. The failing part of this whole project is the expenditure side of it. And to my, Senator, to my knowledge, those answers haven't been answered yet today.
Okay. And that kind of brings me to my next question for you, and thank you for your answers. When did you learn the 2003 financing did not have a performance bond, and what did you do about it?
I don't remember the exact time, but I do know when that came up. Again, I had been county administrator chief clerk for a number of years at the county from 88 till 96 before I went in the legislature. And they were sort of a normal practice for us. And I remember raising that question, and there were a number of meetings, a number of things came through. There was a legal opinion, and there were things put together where people said this alternative security would do the same thing and cost everybody a lot less. It was a little more risk in it, but everybody at that point in time made it sound like it was something that could be done. And in fact, I'm not so sure if they had followed that plan, if we hadn't seen some of this earlier. Because part of that was there was supposed to be 20% of Barlow's money retained. There was supposed to be a security fund put in. I don't know that any of that followed through. And again, that goes to the expenditure side of this thing. Those answers, in my mind, still have never been answered. Those questions have still never been answered.
Do you know when you took those actions?
It would have been prior to us agreeing to the 2003 financing.
My last question for you, sir, is this. Were Mr. Lipsy and Mr. Giorgione ever paid by the county as employees, contractors, or consultants? And if yes, what did they do for the county? I mean, given their roles with the authority and other entities, were you ever concerned that they may have conflicts of interest?
They were paid by the county.
Oh, I do.
They had contracts with the county when I got there. Mr. Giorgione, I believe, was counsel to the Solid Waste Advisory Commission, and Mr. Lispy had a contract with our solid waste department as well as some sort of a consultant. Early on, again, they provided a lot of information. As I had said before, when we got uneasy with relationships, we ended those relationships.
So and maybe I missed it, and I apologize. Were you concerned with the conflicts of interest possibility?
When we became aware and concerned with conflicts of interest, those relationships changed.
Okay, thank you for that. One last question, I'm sorry. On November 21st, 2007, you've certified to the Department of Community and Economic Development in a 8110B certificate that the existing incinerator debt was self-liquidating. Why did you sign this? Did you believe the debt to be self-liquidating? Who advised you to sign? Who did the financial due diligence to ensure the debt was indeed self-liquidating? And are these individuals still employed by the county and or under contract by the county?
Again, at that point in time, I believe that the certification was dealing with the self-liquidation of the retrofit bonds going back forward. At that point in time, we were somewhat assured that if the project completed on time, that there would be enough revenue to make those debt payments. If you look at it, in 2008, when there was another certification that we had to give, we no longer had that same view and did not list them as self-liquidating.
All right, Senator, I'm through. Thank you.
Thank you. Senator Blake.
Thank you, Mr. Chairman. Thank you, Commissioner, for your
Go ahead.
testimony. A lot of what I was planning to ask Senator Fulmer has addressed, but I'm trying to get some clarity on a few important issues, some of which emanate from your testimony and some from your responses to the Senator's questions. The issue, I guess, associated with due diligence, Commissioner, and whether or not you felt that the risk that was being taken on the backs of the county taxpayers was appropriate. The PFM report concerned primarily with the analysis. This is again from the forensic audit, concerned primarily with the analysis of financial terms and structure of the 2003 DEF bonds to provide the county with guidance with respect to a reasonable guarantee fee. With that said, the September 20th version of the borrower projections were attached to the PFM report, suggesting that there may have been some level of evaluation. It is not clear whether PFM reached any conclusions with respect to the projections. While the only thing that was stated in the executive summary is that they make no recommendations as to the reasonableness of the contemplated project, we do find the preliminary debt service schedules and assumptions for the retrofit bonds reasonable. All I'm saying here, Commissioner, is that you were making decisions to put the county taxpayers on the hook. The assessment of PFM was for the reasonableness of a fee, and forgive me, Commissioner, because I think part of what was stated by Matt Evans in your response is the county, this is their representation in your behalf, the county initially objected to the city's guarantee fee. That was advised that the city required the fee proceeds in order to balance its 2003 budget. The county then requested a guarantee fee simply to maintain some level of parity with the city. Commissioner, with all due respect to the fairness issue that you make an argument for, it seems opportunistic. So I'm trying to understand the due diligence process that related to your measure of risk associated with this and whether or not you felt you had sufficient data at that time to put the county taxpayers on the hook for this guarantee.
In 2003?
Yeah.
We did, as I said. This had been going on from about 2000 between the county and the city. I came on board on January of 2003, reviewed all the documentation that was given to the county. We had a number of meetings on this. In no way was this ever taken lightly. And to be honest with you, Senator, part of it was trust between the municipality and the county. And there were a number, and if you have to remember, That was not easy to get to because prior to that time, there wasn't a lot of trust between the county and the city. This was a project where that trust could be strengthened, and the municipality and the county could move forward on working together. And for a while, it appeared that had worked. As far as due diligence, we had an engineer look at it, we had finance people, there were more than one legal firm look at it. There were times that we were not sure it was the right thing to do. But at the end, after all the analysis that was done, a fair amount of discussion among all three board members, people in the community, it was felt, in fact, the media at that time actually gave us kudos for putting the rift aside and actually moving forward. The county was in a position where we were able to help two major parts of the county in one project. And it appeared, if everybody had kept their word and done everything as well, that it would have been a very good project. Unfortunately, it didn't turn out that way.
Understood, Commissioner. And you've made representation that you could not possibly foresee the catastrophic failure of the project, but there's a couple of things I want to comment on, and it'll lead to another question. Part of what your legal counsel has said and part of what your own testimony says is that the forensic audit only looked at the planning and the financing transactions and did not look, to your statement, at the actual implementation or the execution or the construction. I would argue that the actual performance of the project would have informed any follow-on financing, that it should have been a consideration, and it's your own testimony that you were concerned that you weren't getting data from the authority or from the city that gave you an appropriate reassurance about the performance of the project with respect to construction and its.
No, that was the follow-up.
Yeah.
We didn't hire them because the authority in the city had already hired expertise and put all that together. We reviewed that and we had our experts take a look at it. And those folks felt reasonable enough with that they could recommend to the county to support it. It's the execution of the plan that we weren't getting information on. It's the execution of the plan. I still don't know to this day what all happened there. The plan itself, the authority and the city had studies. They had brought things together. We even involved, I forget if it was DEP, DER, at that time, and DCNR and folks at the state on whether even moving to resource recovery was the way for the county to go as opposed to landfill. Because as you know, in this area, there's a lot more landfills than that. And it was in partnership with the state, we took a look at it and said, this is the best way to move forward. So there was a fair amount of analysis done in this. Well, did some people not give us the whole story? It appears that's the case.
Well, but again, following on Senator Fomel's remarks, that the transaction in 6 and 7, again, we're dealing with a facility that was either not functioning, not cash flowing, or at a very limited capacity.
Correct.
And yet a transaction to double down, in effect, on the deal.
And that was not taken lightly either. As I said, my feeling at that point in time is I felt like that Coast Guard rescue person. We were in, and we knew, we could have pulled the plug at that point in time, and the city would have been in bankruptcy. They had made it clear to us that was the case. We decided you can call it double down. We can say we took their word for it, and we wanted to continue that partnership, and we wanted to try to help that municipality, major municipality, the city of Harrisburg, move forward. We knew it was not as ideal as we'd like it to be, but we also knew it was better than allowing them to go bankrupt at that point in time. We still aren't at bankruptcy. Maybe we'll get there, but are we to be penalized for delaying that? I think at that point in time, I still think working with the major municipality within the county, helping them out with their plan and avoiding bankruptcy was still a good thing to do. Was it a little risky? It was. But you know what? There are risky things we have to do every day. And some work, some don't. And it was not taken lightly at any point in time. And there was a lot of public debate about it. There was a lot of public angst about it. And at the bottom line, it was decided we would continue that partnership as opposed to ending it at that point in time.
Understood, Commissioner. Just a couple of things, and I'm not sure whether or not you'll have the ability to answer these questions, but what's your current credit rating, your bond rating for the county? Do you know?
A-.
And was it adversely affected by your guarantee here?
We were put on watch for 1 year, and we were taken off watch the next year because the credit rating agency gave us kudos for the way we've handled the situation.
I see. And do you know the dollar or the percentage of the overall county debt attributable to this guarantee in terms of your debt limit?
The percentage?
Yeah.
Well, we're on the hook for about 145, and our debt limit is about 956.
Okay. All right. Thank you, Mr. Chairman. Thank you, Commissioner.
Sure.
Commissioner, one follow-up question to what Senator Fulmer asked you about the 8110B form. Do you remember who advised you to sign that specifically?
8110B, is that the
That's the self-liquidating form.
I don't know. It would have been our professional team.
What I'm trying to get at is, I know you make difficult policy decisions every day.
You're talking about in 07 still?
No, in 03.
03, okay.
But, you know, there's got to be a system in place and some legal protections for the taxpayers. Who was the one that gave you the legal opinion that the alternative security package was okay instead of the performance bond?
And I believe, and I could be wrong on this, my recollection is there were a number of folks, for instance, Mr. Giorgione on behalf of the city spoke about that, and I believe there was also a document from Rhodes and Simon. Now, I may be in error on that, but that's my recollection.
You had also mentioned earlier that you had conditions in your agreement with discussions about the guarantee. Wasn't one of those conditions that the money would not be used for the purchase of artifacts for the city?
Yes.
Were you aware of the precarious nature of the financing, so that the cash flow from the project could not pay for the bonds, so that when they marketed the bonds, the critical component to investors was the county's guarantee and the city's guarantee? You were aware of that?
I'm aware. They made that very clear to us.
Maybe one last one here. Just a general area of talking about some conflicts of interest that also was brought up earlier. Do you know how much money you've spent on lobbyists and attorneys so far on this general issue of financing?
I don't, but I could get it for you.
And it's interesting as well that the lobbyist that you've used is the same lobbyist that the city's used.
Who's that? I don't believe our lobbyist works for the city.
We're having a little discussion up here about. It's not the city. I misspoke. It wasn't the city. It was the bond insurers.
Sure. They had been our lobbyists for years. The bond insurers, it's my understanding, interviewed a firm from Philly and interviewed them. They actually, the bond insurers saw who we were using, and they interviewed them, and they interviewed a firm from Philly and decided to go with that firm. You'd have to ask the bond insurers why, but I think there are a number of very successful people in this area that have used that same lobbying firm.
So you had them first.
We've had them for years, yes.
And you're sure? Do you know if they work for the city? We still have some confusion whether they ever work for the city.
If they did, I have no knowledge of that.
I don't.
In fact, I don't believe they have. They may have, but I don't know
I didn't
that.
expect you to know that off the top of your head, but we okay? All right. I know you have other meetings to get to, so we appreciate your time this morning.
Thank you.
Thank you.